Free. It's about free expression in America, and the authors are Sam Chaltain and Ronald Collins.
Let me get started in introducing the panelists. We are here today to discuss a terrific new work entitled "We Must Not Be Afraid to Be Free: Stories of Free Expression in America." We'll get in. Everybody see? The book will be on sale after the session, and I think you might be able to prevail upon the authors to sign a copy if you'd like one. And let me tell you about our guests today. They are the co-authors of the book. First, Sam Chaltain is a DC-based educator and organizational change consultant. He works with schools, school districts, and public and private sector companies to help create healthy, high-functioning learning environments. Previously, Sam was the national director of the Forum for Education and Democracy, an educational advocacy organization, and he was the founding director of the 5 Freedoms Project, a national program that helps K through 12 educators create more democratic learning communities. Sam spent several years at the First Amendment Center. Is that where you two met?
It is, indeed.
At the First Amendment Center, and served as the co-director of the First Amendment Schools program. Prior to that, Sam knows of what he speaks. He taught for a number of years in New York, both in the public school system and in the private schools. He taught English and history. And Sam is also a prolific writer and author. His works have appeared in newspapers such as the Washington Post, Education Week, USA Today, and he's author of numerous books, including The First Amendment in Schools, First Amendment Freedoms, a documentary history of the First Amendment rights, American Schools, The Art of Creating a Democratic Learning Community, today's book, and also a book published since this book that we're going to discuss today, The Faces of Learning, 50 Powerful Stories of Defining Moments in Education. Please join me in welcoming Sam Chaltain to the panel today.
Thank you. Thank
you. Ron Collins is an old friend of mine, so that's all I'm going to say about that. No. Ron is the Harold S. Shelfman Scholar at the University of Washington School of Law and a fellow at the Washington, D.C. office of the First Amendment Center. He developed the First Amendment Center's online Supreme Court library. If you haven't ever visited the Supreme Court library website at the First Amendment Center, I strongly, strongly recommend that you do. It's a tremendous, tremendous resource. If that was the only thing Ron had to his credit, it would be enough to make him a true hero among First Amendment folks. Before coming to the center, Ron served as a law clerk to Justice Hans A. Lind on the Oregon Supreme Court, and thereafter was a judicial fellow under Chief Justice Warren Burger at the U.S. Supreme Court. He was elected president of the Supreme Court Fellows Alumni Association in 2008. Ron has taught constitutional and commercial law at Temple Law School and George Washington Law School. He's published some 50 articles in scholarly journals such as the Harvard, Stanford, and Michigan Law Reviews, and his writings on the First Amendment have appeared in the Columbia Journalism Review, The Nation, the New York Times, Washington Post, just to name a few. He's co-author of a number of books, one of which, The Trials of Lenny Bruce, he actually presented at a Virginia Festival book a few years ago in a session sponsored by the Thomas Jefferson Center. He also written The Death of Discourse. A book just came out last year was Justice Oliver Wendell Holmes, A Free Speech Chronicle and Reader, which is right here, and which I just got given as a gift and nicely inscribed, which I'm very grateful for. And of course, today's book, We Must Not Be Afraid to Be Free. Please join me in welcoming Ron Collins to today's panel. Well, let me start off with this question. I think my sense is, not having written a book myself, but talking to a lot of writers, that often the most difficult thing to do in writing a book is coming up with a title. The right title for the work, the few words that encapsulate what the 400 or 300 pages that follow are all about. I'm intrigued by the title of your book, We Must Not Be Afraid to Be Free. Ron, let me throw that to you, maybe Sam. Where does that title come from?
Well, the title really started percolating in my brain about 40 years ago. It was in 1972. I was a law student, and we'd read this case in re Anastopoulos about a young man who'd been denied admission to the bar based on his refusal to answer certain questions about his political beliefs. And I was outraged by the result in it, and I read this incredible dissent by Hugo Lafayette Black. And I can remember sitting at my home reading the dissent, and it closed with, "We must not be afraid to be free." And it just it just touched something in me. And back in 1972, as a student, I saw the statement as a call to action. I saw it as, "We must not be afraid to be free!" exclamation point. Now, move forward some 3 or 4 decades. As a professor in the classroom, it's, "We must not be afraid to be free!" question mark. And I think the difference is that, and basically this kind of speaks to the whole purpose of the book, one of the purposes of the book, I should say. The book moves between the spectrum of fear and freedom. And what causes people to move from the fear side to the freedom side, or from the freedom side to the fear side. And actually, there are things in life that we all, at some pinpoint in time, fear, and rightfully so. I mean, the difference between a hero and a fool sometimes is a fine line. And so we just thought that those themes, fear and freedom, would be wonderful bookends. And since I first came across the statement in connection with Justice Hugo Lafayette Black, one of the great defenders of the First Amendment, it seemed that given the arc of his career, from Ku Klux Klan member to defender of the First Amendment, to somebody late in his life who began to have some reservations about the new freedom that he'd helped bring to America, because by 1968 there's a lot going on. More about that later. So that's where the title comes from. And just a couple things about why working with Sam, it was so wonderful in light of that. I'm the, if you will, the professor. He's the activist. I'm the brake. He's the throttle. I am the professor. He is the poet. And so, just the two of us are different, views, quite often actually quite similar. But it just seemed like working with Sam on this book helped bring that whole idea of "we must not be afraid to be free!" exclamation point, question mark, into sharper focus.
Well, if I can add on to that too, I think that's an interesting way to put it. And in a way, when I think about our give and take over this project, it's you're the law school professor and I'm the historian. And so actually to think about how that plays out in the book through the title, I mean, that title that's the challenge, isn't it, as a nation, as a free nation, whether it's the United States of America or Egypt. We must not be afraid to be free. And then the question is, how do we operationalize that to the fullest possibility? And so to some respects, what this book is about is a series of stories of people who made up some of the most seminal cases in the history of free speech law. But it's about both the what, what does the law now say? What did the law say? What was the process by which we either expanded or constricted our understanding of freedom, which is very much, I think, following the lead of Ron and of the law school side of the equation. It's also very much about the who. It's about who were these people? What were their particular challenges and opportunities? Who were these heroes? Who were these villains? What did their stories tell us about ourselves and about our ongoing challenge as individuals and as citizens in the 21st century democracy to do better than our forebears at understanding that fundamental question of what does it mean to be free? And so what we hope, what was certainly fun for us as authors and what we hope will be fun for those of you as readers, is to experience those stories through both the what and the who.
Just if I could put a little tail on that kite, for those of us who teach, particularly in law schools, it's amazing. Law schools quite often, and here I'm generalizing, of course, but quite often the whole purpose is to suck all of the life out of a case. That it's all reduced. It's all reduced to black letter law. What were the facts? What is the issue? What is the rule in the case? And, the rest, the people, the story, the drama, the suffering, the agony, the defeat, it's all sucked out. And so one of the things that we try to do is take a different perspective. And I just see that David O'Brien from the University of Virginia has just joined us. And David, when he writes on constitutional law, keeps the life in the story. And so, welcome, David. But it's very hard for those of us who teach law to put a dollop of life in it. And that's what Sam and I attempted to do in this book.
Yeah, I think you talk about getting to know the people behind the cases and the stories and the law. Perhaps the most prominent person in the book, or at least seems to come in and out, is somebody you mentioned already, which is Supreme Court Justice Hugo Black. And my sense is that I don't want to say an ambivalence comes through about Black, but there seems to certainly be a dichotomy, if you will, or two sides to Black, at least in terms of the First Amendment. He comes across definitely as a hero, but in some ways, I think, maybe this is too harsh a word, but to some degree, you might describe him as a villain. Could you both speak to that?
Well, villain is a bit tough, but let me go with it in the spirit of the First Amendment. If you believe in freedom, you will believe in risks, and risks are something that most people are averse to taking. Unless, of course, they're 16 and under the influence of something unlawful. But
You're telling us something about last night, Ron?
But the idea, if you defend First Amendment principles, you have to be willing to defend not only heroes but villains. You have to be willing to defend the First Amendment rights of people that do despicable things, like protesting at funerals. And the United States Supreme Court has just upheld by an 8-to-1 margin the First Amendment right of people with certain limitations on time, place, and manner to do that. So we thought that Hugo Lafayette Black was a wonderful kind of example, because here you have a man grew up in Alabama, was a member of the Ku Klux Klan, was a powerful democratic force in the democratic force in the United States Senate. FDR nominates him to the Supreme Court. He comes to the Supreme Court, His first law clerk is Jewish, his first secretary is Catholic, his first assistant is a person of color, and his first opinion is on civil rights. And it looked like this KKK member had just done a 180. And then, for the decades thereafter, he leads the charge for First Amendment freedoms and other Bill of Rights freedoms. And so in that respect, you see the hero of Hugo Black. But by 1968, when the country is being torn apart, he has some very serious reservations. He doesn't believe that wearing armbands, for students who wear black armbands to protest the war, he doesn't believe that that's protected by the First Amendment. He doesn't believe that marching and demonstrating in the street is protected by First Amendment. In other words, Hugo Lafayette Black came to fear the very freedom that he helped bring. I don't say this in a pejorative sense. Each person can read the book and make of it what you will. At some point, ladies and gentlemen, we all draw lines. At some point, we all put the brake on and say enough. Any of you who've been a parent, I'm sure, have exercised those rights. And then finally, in 1971, when the Pentagon Papers case comes up, and the whole question is, if you can believe this, can somebody release papers and leaks about national security? I mean, that such a thing would be protected by the First Amendment? And the U.S. Supreme Court says yes, and Hugo Lafayette Black says absolutely yes. You wonder today, in like of WikiLeaks, how it would play out.
And it was his final opinion, and he died just weeks after its delivery on Constitution Day. But part of the reason that Black provides the perfect point of entry to the meta-narrative to a series of stories is because his challenge is very much the challenge that each of us faces, back to the core question in the title. And part of what we see happen over the course of Black's own life is, we all know this, but democracy is the least efficient, least orderly way of going about organizing a society. It does not lend itself well to tidiness. And so in the early stages of Black's career, as Ron referenced, we have this person who famously said, you know, no law means no law. He's as close to an absolutist as the court has. And then as his tenure continues, as he ages, and as the nation enters, as the world enters a year of revolution, 1968, arguably the greatest year of revolution since 1919, and I would say 2011 is the first true global year of revolution since 1968. So as he enters that cacophony and young men growing their hair long and people protesting in the street outside of his offices, and the assassinations, I mean, just if we think about 1968, right? The Tet Offensive, assassination of Martin Luther King, riots all over the country, Bobby Kennedy, the Democratic National Convention in Chicago. And again, this is just what's happening here in the United States. There are revolutions all over the world at this point. Black starts to waver. And in a way, who can blame him, right? Because what he's seeing is the possibility that the society, the open society, the robust, absolutist embracing of free expression rights that he has come to champion over the course of his career may in fact be leading to the very undoing of that republic. That it may literally be that we are witnessing the beginning of the end in Black's mind in 1968 of our democratic experiment in liberty. And so the idea that he does a 180, the idea that in the end, although he does have the swan song of the Pentagon Papers, he comes to start ruling against some of the very things that he holds most dear, is such an important reminder to all of us that it's hard. It's hard to fully embrace what it means to be free. And for all of us, we can all answer the question, I'm all for free speech, but...
Free speech for me, but not for thee, as Nat Hentoff once put it. One of the things we mentioned in the epilogue of the book is, you know, it's 1968, between 1968 and 71, you have this whole counterculture, you know, it's this, you know, charge against, if you will, American values. And who's one of the people leading it? Charles Reich. Any of you over the age of 50 may remember that name. He was the author of The Greening of America, one of the best-selling books of its time. And here's Charles Reich kind of leading on, you know, a new consciousness, reject the old consciousness, the old way. Who was Charles Reich? Charles Reich was a former law clerk of Hugo Black. Not only was he a former law clerk, they had a very strong bond between the two. I think it's fair to say that they loved each other. I mean, Reich had enormous respect for Hugo Black and admiration, and the feeling was quite mutual. Reich had written several things honoring Hugo Black, but when he writes The Greening of America, and you go to the Black library and you look at his own personal copy, in the margins, he writes, I disagree, exclamation point. I still believe in this country, exclamation point. Here was, if you will, Hugo Black writing the dissent to The Greening of America. And again, you know, the way we've written the book is such that we don't say Black is the villain now or Black is the hero now. We let the readers decide for themselves. But it is an interesting to watch the arc move, you know, to watch him move across the spectrum. And there but for fate go you or I, you know. I mean, if we were tested as he was tested, would we? In fact, well, we could talk about some of the cases and talk about this.
Well, I don't want to focus just on Justice Black because the book is about so many more people, but I did at any time Justice Black himself recognize this difference, or did he see himself as entirely consistent?
Well, he came up with a number of doctrines. You know, he says you protect speech, not conduct, you know, that sort of thing. But, you know, to say that wearing an armband is conduct, I mean, you know, it's what we call symbolic expression. So, you know, no, Black never, he never did admit any inconsistency.
The only thing I would add is just this is a reminder of why we all need a community to fully understand ourselves. You know, sometimes it's hard to gain the perspective on one's own behavior, and I think that was true of Black. So he was incapable on his own of seeing the way that he had strayed, and it's only through the benefit of the community that we can, as a community, hopefully gain some wisdom and understanding from his journey in ways that will better improve our own journeys.
You know, along those lines, it got me thinking, not only was Hugo Black quite often a great defender of the First Amendment and really kind of ushers in the new ethos for protecting First Amendment rights with all his shortcomings, but he was also a very patriotic American. He had a profound love for this country. And it shows, particularly these days, how one can be a patriot and at the same time have a firm belief in those principles of the Bill of Rights and the First Amendment.
Well, the book really is a book of stories, if you will, that just happen to all be about free speech and free expression, and in many cases, of course, that have shaped that. I'm just curious, what are some of your favorite stories from the book, your personal favorites?
You want to go first or second?
I'll let you go first. Age before.
So it's tough to choose, but so Benjamin Gitlow. So since we're talking about revolution, right? 1968, 2011. Let's go back to 1919. So it's the year after the end of the First World War. Bolshevism is on the march. Eugene Debs has received over 1 million votes in a presidential election. There's a lot of fear about the extent to which our republic will stand, and there's a lot of backlash. And Gitlow is among the members of this new socialist movement, but he's a part of it. He's a part of the movement that felt that regular socialism wasn't left enough, that they needed to go further in what they were advocating. And so Gitlow became a part of something known as the left wing. So again, think about how far to the left socialism is. This is the left wing of socialism. And immediately they were like, well, if this is going to work, we've got to come up with our own manifesto. We've got to draft something that's the equivalent of what Marx and Engels did in 1848. So with Gitlow as the business manager, not the author, they draft something called the Left Wing Manifesto. And they print up about 20,000 and they distribute it throughout New York. It didn't work. In fact, one reviewer said that the manifesto was so boring that the only way it would incite a riot would be to do so against the author.
It's true.
But it didn't matter because there was a law in the books in New York State, coincidentally passed in 1902 after the assassination of then President McKinley in Buffalo by an anarchist in 1898.
Can I just put a footnote in there?
Yeah.
Because of McKinley's assassination, McKinley didn't nominate the person to the Supreme Court that he had planned to. And when the new president, Roosevelt, came in, he made his first nomination to the Supreme Court, Oliver Wendell Holmes. In other words, Justice Holmes wouldn't have been on the court but for the work of an anarchist. Go ahead.
How do we not have that as a footnote in the book? After all the time that we did this, that's the first time I'm hearing that.
It's in my Holmes book.
Oh. You got to spread the wealth.
Okay.
So there was a law in the books in New York that basically said you can't do anything you can't say anything that's critical of the government. And in fact, at that point, 1919, 35 of the then 48 states had laws on the books that basically said you can't say anything criticizing the government. Now we think, how is this possible? And yet, up to this point, remember, the First Amendment reads, Congress shall make no law. So the First Amendment was a limitation on what the federal government could or could not do. It was not a limitation on states. And so guess what? If it's not a limitation on states and states are free to do as they wish, well, again, we must not be afraid to be free, but we are afraid to be free. We are still afraid to be free. We were definitely afraid to be free in 1919. And so Gitlow was tried and convicted all the way up to the Supreme Court and ended up even losing at the Supreme Court level, 7-2 decision. It was a rout. But in the majority decision, for the first time, the justice authoring the opinion, Justice Sanford, said, we may and do assume that the freedom of speech can be applied to the states by way of the 14th Amendment. And just kind of a brief context about that, and then I'll let you tell the end of the Gitlow story. So you may recall the 14th Amendment was the one that was passed in 1868, right after the end of the Civil War, primarily to protect the rights of recently freed slaves. Although the language is, of course, meant to go farther than that. And one of the things that's guaranteed in the 14th Amendment is that we all have the right to due process of law, that no state shall infringe upon any person's opportunity to have due process of law. So this was the first time that the Supreme Court looked at that aspect of the 14th Amendment and said, that incorporates an application of First Amendment freedoms to the states. And one of the things that's very striking to me, again, I've never been to law school. I'm a historian. I worked at the First Amendment Center, so I feel like I have a deep well of knowledge about the First Amendment and nothing else when it comes to the law. And I remember when
it's true.
Yeah. And I remember when I first learned that, it was shocking to me that it wasn't until well into the 20th century that the First Amendment applied to the states. And then gradually, over a series of other cases, the rest of the First Amendment's 5 freedoms came to apply to the states by way of the 14th Amendment. So to me, and there's an end to the story that I'll let Ron tell, but what I love about the Gitlow example is earlier I was talking about having the what and the who. So on one level, that story is a way to explain to the readers the principle of incorporation, the what of incorporation, how the First Amendment came to be applied to the states. But that can be a very dry story if you're only focusing on the what. When the who, Benjamin Gitlow, this person that was attempting to seed revolution in this country and who was arrested and ultimately tried, and there's more to the story, that's what we hope will breathe more life into it.
Just, I'm going to ask Sam to say one more thing before I say how the Gitlow story played out. It wasn't that people at the time just feared his writings. There was a lot more context that was going on. There were bombings going on. Can you say a few words about that?
Yeah, so also in 1919, there were, I believe, over 30 different mail bombs that were sent to key public figures across the country as a part of this wave of anarchy and revolution. In fact, one was sent to Supreme Court Justice Oliver Wendell Holmes. Severe calamity and mayhem was avoided both due to luck and insufficient postage in a lot of cases. But there was one, and here's just an example of some of the folks that come through in these stories. One anarchist was not so lucky. He was trying to personally plant the bomb in the front yard of then Attorney General Mitchell Palmer. You see the Palmer raids coming, and now you have an understanding exactly why he was so motivated. But as he was trying to plant it, the bomb blew up and blew his head off and across the street into the yard of then Assistant Secretary of the Navy Franklin Delano Roosevelt. Just a little tidbit for you. But so what followed after this reign of terror through mail bombs, I mean, this is very much domestic terrorism, was then Attorney General Palmer being helped by a very ambitious young 20-something named J. Edgar Hoover to launch the Palmer raids and sweep up thousands of anarchists across the country, including Benjamin Gitlow.
Anarchists and foreign-born people as well, many of whom were quite innocent. What's interesting, there's so much that's interesting about the Gitlow story, and any law student can go and read cases and never be exposed to any of this. But after Benjamin Gitlow his conviction is upheld by the United States Supreme Court with Brandeis and Holmes, with Holmes and Brandeis in dissent, he's at Sing Sing prison. And on the occasion of his first anniversary, wedding anniversary, Badana Zeitlin, his wife, visits him. And in the course of their visit, she gets a phone call, and she comes back and tells the officer there that they will soon be releasing one of their, as she put it, guests. He'd been pardoned by the governor of New York. And so Benjamin Gitlow receives a new suit and $10 and leaves with his proud bride, Badana, and goes off to the train station. And when he's there, he's greeted by a group of socialists and basically says, "Today, tomorrow, and forever, proletariat of the world, unite." it's a glorious moment for a man who stood up and defended freedom. As the years passed, he had a falling out with the Communist Party, both here and in Russia, and essentially was booted out. And as the clock ticks and as the days pass, he becomes a government informant and testifies before the House on Un-American Activities Committee. And among others, he accuses 600 Methodists of being communists and Rabbi Stephen Weiss as being a communist. And when Benjamin Gitlow dies, the only publication that has anything to say even remotely kind about him is the National Review. It's an incredible story about a man that moved from fear to freedom, and then from freedom to fear.
You mentioned Nat Hantel's quote of free speech for me, but not for thee. And I think that it's such a great statement about how people actually view free speech, even though they don't admit that to themselves. Could you talk about, in the history of free speech, does there seem to be a common political origin to the villains of free speech, if you will, the threats to free expression? Because there are a lot of people who would claim that they are, strong defenders of free speech, but just as you said, is taking that a step further, can we look and see any kind of common political viewpoint from which threats to free speech come, or do they come from all over the political spectrum?
If you're Federalist, anti-Federalist, Whig, Democrat, Republican, Tea Party, whatever, at some point or another in history we could find examples of people, if you will, pushing the censorship button. The anti-Federalists lead the campaign, at the birth of this nation, against the Federalists. What did the Federalists do who brought us the Constitution and thereafter signed off on the Bill of Rights? They passed the Sedition Act. Round them up, bring them in, Of course, when the election of 1800 comes, the Federalists lose. And Thomas Jefferson comes, and what does he do?
Be careful now. Remember where you are.
Oh, yeah, right. We're in Virginia.
You're in Charlottesville.
Oh, my God. The cradle.
Would you like to start over?
Let me just put it diplomatically then, in memory of Thomas Jefferson. He returns the favor. And, this is, Lincoln during the Civil War, and people have different views about that. Woodrow Wilson, I happen to be of the liberal persuasion. George W. Bush was, I was going to say not one of my favorites, but that's putting it mildly. But if I had to look at what Bush did in light of 9/11 and what the Democrat Woodrow Wilson did in the First World War, there's no comparison. Woodrow Wilson just pulled out all of the stops and really abridged First Amendment in a way that, Bush, whatever one makes of him, never did. And so, it doesn't really matter, Democrat, Republican. And one of the things about the First Amendment is be careful what you protect. It's all fine to protect heroes that go out and fight the good fight with which you agree. But how about the bad fight with which you disagree? How about when they're funeral protesters, or my wife, very strong advocate and works in the area of women's reproductive rights, we tend to have most of the same views, except when it comes to protesting near abortion clinics. Then our views diverge radically. And of course I say, well, you just don't believe in liberty, and she says, well, you just don't believe in equality. And so, it just depends on, whose ox is being gored.
Yeah, and actually the question makes me think about it in a slightly different way, which is that throughout the book there are both heroes and villains. There are some people that appear throughout who serve in both capacities. And I think if you look at the key figures in the history of First Amendment jurisprudence, it's a reminder that we all have the capacity to be heroes or villains when it comes to this issue. So, as was mentioned at the beginning, I'm an educator first and foremost, and a lot of my work is to try to help schools create the best possible environment to teach young people how to be active and responsible stewards of freedom. And one of the things that I observe related to this question is that I think too many of us, we have a very overdeveloped sense of rights and a very underdeveloped sense of responsibilities. And the way that can be applied to the First Amendment is we think that many of us, too many of us, believe that the First Amendment exists to give me the right to say whatever I want to say. And I am a passionate defender of the First Amendment when those I agree with are being protected by it. Whereas, of course, that's not the idea at all. First Amendment exists to protect the least popular speech, and I can think of no better example than the Phelps case, than that type of message being conveyed at a funeral for fallen servicemen. I mean, you won't get a more offensive type of speech than that. But what the founders envisioned was that the First Amendment exists to give us all the right to say what we must say. And the beauty is that there is no one way to answer that question, back to the who. So the challenge as a member of as a citizen in a free society is, of all the things that I can say, what must I say? What are my causes? And to what extent will I become a passionate advocate for them? And so my question is, to what extent are we proactively creating schools and environments for young people to actively decide what it is that they must say, as opposed to reminding them that they live in a world that exists to let them say whatever they can say? And I think that's more in the spirit of the First Amendment.
Josh, I'd just like to say, just a couple of, Sam mentioned his case, and I wanted to just say a few words about one of my favorite cases. Before I do, just a quick little tail on the kite of what Sam has said. In high schools across this nation, a number of students are taught the gospel of the First Amendment, or at least hopefully they're taught it. But in terms of what high schools practice, they all too often do not practice the principles, the teachers, the officials, the community officials. They all too often do not practice what they preach.
And it is because of fear.
And it is because of fear, quite often, sometimes founded, sometimes unfounded. Just a couple of things. One thing I actually should say is one of the cases, one of the stories in the book is about a man named George Anastopoulos from Illinois, who's still alive. In the 1950s, he graduates from the University of Chicago. Abner Mikva was in his class. I guess Judge Bork, or Robert Bork, was also a fellow student. He graduates at the top of his class, University of Chicago, would receive a PhD from the University of Chicago as well. Very bright young man, rather conservative, not conservative necessarily in a political sense, although that too, but conservative in just a traditional kind of manner. Rather, some say courageous, some say stubborn. But anyway, he graduates and passes the bar, is offered a job at a prominent law firm, and is all ready to begin his career, has a wife and a new child, and life is good. And then he goes down and appears before the Committee on Character and Fitness, and it's just a pro forma thing. They ask these people questions, and you answer them, and then move on, and you're admitted to the bar. And they ask him what he thinks are the great principles of America, you know, and he says the right to revolution. The right to revolution? Do you mean that seriously, Mr. Amsterdam? Yes, yes. Well, a lot of communists and anarchists and others are talking about that these days. Well, he said, but you can't be an American and not believe in the right of revolution. I mean, isn't that what this country's all about? And so they ask him, are you now or have you ever been a communist? Well, I mean, anybody who knows anything about George Anastopoulos, he's many things, you know, but a communist. I mean, everybody in the city of Chicago knew that George Anastopoulos, including the people asking the questions, knew that he wasn't a communist. He said in so many words, it's none of your business. And he stood not on the Fifth Amendment right to remain silent, but on the First Amendment right. you don't have any right to inquire into my political beliefs. The case goes to the United States Supreme Court. He loses 5-4. Hugo Black writes an incredible dissent in the case, from which the title of this book comes. Now, when you hear the story told from this vantage point, it's easy to hold George Anastopoulos up as a hero, and in my view, he is. But the story isn't quite that easy. Ask yourself, if it were the 1950s, you're his wife, Sarah. He's just graduated at the top of his class. He's just been offered a job at a prominent firm. You have a young daughter. Your everything depends on his income. Would you, if you were his spouse, say, George, this is very honorable. It's great that you're going to sacrifice your career, as a lawyer, and that you'll subsequently be a taxi cab driver, although today he's a law professor. But then, in those days, it was a little different. If you were the spouse, would you just say, I side with freedom? Well, Sarah Anastopoulos did. But how many spouses might have a different perspective? And again, it depends on, whether or not you see this through the lens of freedom or you see it through the lens of fear. And I dare say, I could imagine many a spouse having reservations and saying, look, George, everybody knows you're not a communist, right? So what's the big deal, right? Just answer the damn question and let's move on with life.
Well, I'd like to explore the idea. We talked about the villains quite a bit, and you've touched on the idea of heroes of the First Amendment. Of course, the problem with heroes, calling heroes the First Amendment, some of the heroes are pretty despicable people. When we talk of the, perhaps in the sense some people might say the Phelps are pretty despicable in terms of what they do.
People who burn flags.
People burn flags. All sorts of things. These are folks who have defended the First Amendment successfully. I'd like to focus more in the traditional sense of a hero, or just to get a sense of some of the characters. Who in the book are some of your favorite heroes in the classic sense, that they've defended speech that they themselves hated, that they've defended people and causes that they truly despise themselves?
Well, it's sometimes it's a little more complicated. I mean, so for example, you have William Kunstler arguing the flag burning case. Anybody who remembers the radical lawyer William Kunstler, I'm sure that he was happy, pleased to argue that case.
And Clarence Darrow defended Gitlow.
Clarence Darrow, yeah, it's true. Clarence Darrow was one of the trial lawyers, and Clarence Darrow and the other lawyers had told Gitlow not to take the stand, and he ignored their counsel and went on with all his, proletariat propaganda, and just infuriated the court and the jury, much to their dismay. But sometimes it's a little more complicated. I want to answer your question, but I just want to throw in it's a little more complicated. If you go, we all see Brown versus Board, 1954, as a turning point in racial justice, in the politics of racial justice in this country. But it took years and years and decades to implement it. And the fight in the South and elsewhere to make that implementation impossible was quite strong. And one of the things that a number of states did, including Alabama, is they passed laws that required that the NAACP, in order to do, quote, business in that state, had to turn over its membership lists. And there were two people, then Thurgood Marshall leading the charge for the NAACP, and his assistant co-counsel, a man named Robert L. Carter. Marshall thought initially that they should comply with the order given by a trial judge in Alabama who threatened fines from $10,000 to $100,000, that they should comply. Robert Carter said, no, we should not. This will break us here and everywhere. And by the way, thereafter, many states and counties across the country, particularly in the South, started passing similar laws. Robert Carter, and I don't think this story is told anywhere except in our book, if I could put it in that plug, argued 8 cases, First Amendment cases in the Supreme Court, and won them all. And I think it is a fair statement to say that but for Robert Carter coming in and stepping forward the way he did, the NAACP could not have continued to do what it did to implement Brown. So, you know, you have those sorts of situations where, you know, everybody was so focused on the equality principle. That was the whole idea. And then Robert Carter had this idea. By the way, when Robert Carter was a student at Howard University, he sat in his dorm one night at 9:30 p.m. and listened to the radio. And who was he listening to? He was listening to Hugo Lafayette Black, who went on national radio and spoke about his days in the Klan.
Well, and just to give a little, so this is my favorite chapter, is the chapter about, and the what is the right of association, which came into being as a legal principle because of all these cases that Carter fought. But the reason it's my favorite chapter is because I think it's the best marriage of law and history. So we have Robert Carter, who's a child of the Great Migration, is one of 8 children to a single mother, and educated, rising in the NAACP, fighting all of these cases in states across the South against the backdrop of not only Brown, but the integration of Little Rock, the assassination of Medgar Evers, the March on Washington, the passage of the Civil Rights Act. All of these things are happening, and Robert Carter is a part of that whole fabric being stitched. His primary opponent is Judge Walter Jones, who's a child of the old Confederacy. Jones's father carried the flag of truce from Lee to Grant at Appomattox. Jones had been on the bench in Alabama for over 4 decades, had written, literally, the book about trial law in Alabama that people like Carter were using, and then Jones would say, well, actually, you got it wrong. I mean, so Jones was just being completely hypocritical. But he had said, Jones says this, I intend to deliver the NAACP a mortal wound from which they will never recover. And in the backdrop, you have Hugo Black, who is, now we're entering the 60s, so we're starting to see the pivot in Black's own thinking. But in terms of the cases that Carter is arguing, Black is largely still on the heroic side of freedom. But the chapter begins, and this is what Ron just referenced, with a night in October 1937. Black is the surprise nominee by FDR. Now think about this in modern day, right? So Black is a surprise nominee. The confirmation is coming up, and then a Pittsburgh newspaper breaks the story that Black had been a member of the KKK and finds all of this documentation. Can you imagine today if a potential Supreme Court justice is exposed as a previous member of the KKK? Game over. And yet what happens is Black is hastily brought back from a vacation he had been taking with his wife, and he needs to address the nation. And he does, and explains his own belief about freedom. And at that point, Carter is a young 20-something in Columbia working on his dissertation about the First Amendment.
Just a quick answer. There is a man named Edward Cleary, who is now a judge in Minnesota, and he was a public defender in the 1990s. And Edward Cleary is asked to defend somebody who burnt a cross on the front yard of African Americans, hate speech. And here was somebody, Cleary, the lawyer, who was very progressive and certainly, you know, had no stock at all in people who perpetuate hate speech.
But and it's 1992.
1992.
We're saying this is not way back in the
right.
day.
And defended that right. You know, in the United States, there's many countries that prohibit, and perhaps rightfully so, hate speech. In the United States, we permit it. The idea is not to censor the speech, but to counter it. That is, you know, and I'm hoping that somebody will go to the home of the Phelps, the people that protest at military funerals or where they work, and protest against them. I mean, it hasn't occurred to anybody yet to do that. But the idea that Louis Brandeis gave us is not to censor speech, but to, you know, bring on more speech. When the Phelps were thinking about protesting, it just shows how their minds work. Protesting at the funeral of the young woman that had been murdered recently in Arizona. by an assassin's bullet. They were actually going to go there and protest. And it's a wonderful story, First Amendment story. I wish we could have had it in the book. It was too late. A young woman in her teens has the idea that she's going to engage in symbolic expression, and that they were going to have angels' wings, which were sheets that they were going to hold out, and they built a circle. And at first there were 10 people, 50 people, 100 people, thousands of people. And the idea was so that Phelps's terrible acts couldn't be seen. And this is a wonderful example of counter-speech, of more speech, of exercising your First Amendment right. And when it was all said and done, guess what? The Phelps decided not to protest there.
And to me, when I think of that story, that's what makes me think God bless America. Both sides of that story.
Yeah, and there are actually other examples with the Phelps of a group of motorcycle riders that call themselves the Patriot Guard that will often go to the Phelps protest and block any sight of the Phelps by their much greater numbers of people. And in fact, the case decided by the Supreme Court, there were about 100 Patriot Guard riders there demonstrating their support for the young fallen soldier, as opposed to 7 Phelps. So it's a perfect example of the counter speech, or the answer to speech you don't like is more speech.
It may not be the best method, because other countries, enlightened countries, Germany and other countries in France, have different ways of looking at this. But it's our tradition, and I'm very comfortable with it. And I think it is, it may not be. Freedom is an experiment. And as Holmes said, experiments sometimes fail, but until they do, I think it's worth the risk, and that's one of the themes that we try to talk about in the book.
And freedom depends on civil friction. The only way it really can survive is if we build in ourselves the skill set and the capacity to be comfortable with the discomfort of competing ideas, and the confidence and the clarity to know, again, what it is that we must say in that marketplace of ideas and how it is that we should go about expressing those ideas. Those are the skills of free people.
Well, that brings me to, and in fact you may have just answered it, but I'm sure you can come up with another example of my last question before I open it up to you folks to ask.
And we urge you all to exercise your First Amendment right.
Which is, what are the, if you will, what are the lessons? What are the themes that you hope somebody who reads this book will take from it? Sam, I'd like to start. Or
that it's a remarkable starting point to have created a society based on the revolutionary notion that all human beings, not all citizens, but all human beings are endowed with certain inalienable rights, and that we have committed as a nation, as a community of people, to go to the greatest extents possible to protect all of those rights and make them sacrosanct. And that ain't enough. The only way that we can truly move from the industrial age to the information age to what I think we are now entering globally, which really is the democratic age, is if we remember that we've been at this for over 200 years and we've still got a long ways to go. We have not figured this out. So to me, the most valuable lesson is we need to stop thinking of democracy, of the First Amendment, and of freedom as fixed concepts that we here in the United States have come to fully understand and can easily export to other places. That we also are only in the earliest infant stage of understanding truly, deeply, operationally what it means to be free, and that we should not be afraid of that. That there is great power and opportunity in recognizing our own process and the fact that we still have a long way to go, but the goals, the aspirational goals that we set over 200 years ago are still the right goals. There is nothing wrong with what we are aspiring to. There is a long way for all of us to go in being able to actually live up to it.
I would just say that the next time you hear an idea that offends you, the next time you hear somebody saying something that you find outrageous, take a deep breath, pause, all right? One of the virtues of the First Amendment is toleration, that we tolerate that which is otherwise seemingly intolerable, all right? Pause. So I think one of the lessons of the First Amendment is a certain restraint, all right? A certain idea that maybe we don't have it all right, all right? Maybe there are different points of view. Maybe there's something to be said for the other side, or maybe it's just a matter of letting someone howl at the moon, all right? A little nod to the late Allen Ginsberg. So there's that side of restraint. And I think the other side is activity. When others step back and remain silent, step forward, speak up. It's amazing how often people don't exercise their First Amendment rights, that when something is to be said, they don't say it. There's an adage, tell your boss what you think of him, and the truth will set you free. You know?
That person was fired.
But there are times, and they're not just cinematic moments, ladies and gentlemen, all right, where the honorable thing is to step forward, is to speak your mind, is to be, if you will, that lone wolf howling. And that, I think, is one of the great lessons of the First Amendment as well.
Well, thank you both very much. Well, I'm going to now let the audience be the moderators, but before you, I do ask you to raise your hands and then wait until the microphone gets to you before you ask your question. Before I do, though, we're going to take the first question. I'm going to, normally I'd wait till the end to give a gift, but given today's topic, I thought it's appropriate that I give it to you right now. One of the things that the Thomas Jefferson Center does to celebrate the birth of its namesake, April 13th next year, is for the last 20 years, we've been giving out what we call our Jefferson Muzzle Awards for the most ridiculous or egregious affronts to free speech to have occurred in the past year. And very shortly, we'll be giving out, as I said, the 20th edition. And so I'd like to give you both, to make sure you have it, the official Jefferson Muzzle T-shirt. Can you get that in close up with Mr. Jefferson muzzled right there? And I have a little something else for you. It's one size, and I'm
so relieved. I thought we were going to get the award.
Muzzle, no. I invite you all in the audience and those of you at home to visit the center's website at www.tjcenter.org to see the 2011 Jefferson muzzles. Now, questions, please. I'll start right here in the front, and the microphone is coming to you.
Thank you. A comment and a question about Boston. Comment is that in the early 1770s, a young lawyer in Boston defended the British soldiers who were responsible for the Boston Massacre. His name was John Adams. Probably a lot of people know that. Number two, since it was published about 3 years ago, my favorite novel remains Dennis Lehane's The Given Day, which is a fictionalized version of the Boston police strike in that seminal year of 1919, as you mentioned. Does your book have any story in it that references that event?
No, we do talk.
I'm going to write that down. What's the title again?
The Given Day by Dennis Lehane, the same fellow that wrote Mystic River.
No, we don't. Actually, there's another 300 pages, literally, that are on the cutting room floor, and that may well be the sequel to this. So we kind of had to, Mr. Adams did sign off on the Sedition Act and the trial against Thomas Cooper, among others, the famed publisher. I don't think he was comfortable with it, but he did let it happen. And you know what the Federalists did to the Anti-Federalists was just incredible.
Because it's like a bookend to what's going on in Wisconsin. It's the first of the public employees strikes.
You have other questions?
All right, thank you. Next question. Yes, sir. How about right over here in the front? We'll work our way back.
First, I have a comment, then I have a question. The comment deals with your layout of the front cover. I noticed that you have some of the text of your cover or the title in bold, and the bold reads, "We must not be free." Now, is that a design blunder, or was that on purpose?
You know, I'm so glad you mentioned this. And this is a First Amendment lesson, believe it or not. It all depends on how you look at it. If you stand at a distance, the word that's most prominent that you see is free. If you look at the spine, the word that sticks out is afraid. So that you would look at it and see it that way is one thing. Some people look at the cover and think that it's Lenin, not John, the other fellow, when it's a famed activist from the time, Charles Ruthenberg. So it all depends on how you look at it.
My deeper question is I've attended a number of events here and two in this chamber, and it seems to me that a lot of this constitutional talk is academic, because in practice, democracy has been eroding for at least 40, maybe 50 years in this country. And I think the Supreme Court recently put the last nail in the coffin when they voted "we the corporations" rather than "we the people," when they permitted corporations unfunding for our elections.
Well, let me just, again, how you look at it, I respect your right to dissent from my view, is certainly not new. It goes back well over a century, and I think every member of the Supreme Court since 1880 at one time or another has signed off on protections, constitutional protections for corporations. And in fact, one of the people that helped bring that idea to us was Robert R. Carter, the co-counsel for the NAACP, because the NAACP is Inc. It's a corporation. Now, albeit it's a non-profit corporation, but it's still a corporation. So the idea of protecting corporations is hardly new. The idea of protecting corporations for First Amendment purposes is certainly not new. And then the question is are you going to say, well, for-profit corporations not protected, non-profit protected? Well, then what about groups with which you disagree, the NRA, and one can go on and on. So reasonable people can have differences of view, but I think it is important to remember that the idea is not new. It was pitched as new, and if we take protection away from First Amendment protection from corporations, we stand a lot to lose. By the way, in a recent case involving the Freedom of Information Act, they said that the privacy protections, the Roberts Court said the privacy protections of the Freedom of Information Act do not pertain, this is for statutory purposes, to corporations.
Just to underscore that point, part of the reason that I concentrate my work in schools is to your observation about the gradual erosion of our capacity to really breathe life into these principles. I will also say I think it's impossible to ignore the inherent tensions that exist between democracy and capitalism. And I'm not suggesting that that there's a better way. I'm just saying there's an inevitable tension when we get to the very core idea of freedom. I will also say, to the point about corporations, really interesting evolution about how that came to be. Between 1890 and 1910, there were about 300 cases that went before the Supreme Court that dealt with the rights of corporations. But because of some very clever lawyers at the turn of the century, what ultimately changed was the definition of the word person in the 14th Amendment. And so of the cases that went before the Supreme Court at the turn of the century, 288 dealt with the rights of corporations, not with the rights of individuals. Although I think it's safe to say that when the 14th Amendment was written, they meant persons as persons.
And you think that those who preach the originalist gospel would be mindful of that, but we have other questions.
Next. Yes. And we'll go to you next.
Free. Free seems to be a rather relative term. And I wondered in writing this book if you had a definition of freedom in mind, because a few times, Ronald, you interchanged the term freedom and liberty, and I wondered if that meant the same thing to you. And Sam, in your introduction, are you part of the Democratic School movement?
Answer in turn.
Freedom is just another word for, you remember that Janis Joplin line. Yeah, I mean, freedom, liberty, I think I'm comfortable using them at least for now, interchangeably. What's important, and this I think is something that Sam built on. Well, first, I think the two great principles of constitutional government in America, well, three, separation of powers and checks and balances, one, liberty and equality. I mean, I think those are the great principles. And sometimes liberty and equality, as I mentioned with the protests at abortion clinics and elsewhere, sometimes those conflict. Or race hate speech, somebody'd say, in the name of equality it shouldn't be protected, in the name of liberty it should. So there's that tension. And I think when you talk about freedom, and then Sam hit it, you have to talk about responsibility as well. It doesn't necessarily mean it's government-imposed responsibility. But in order to be a free nation, we have to be a responsible nation. That when people engage in race hate speech, we have to counter it. You know, that we cannot allow certain abuses to take place. That we should counter them as best we can. So I would only say, in the interest of time, that with that freedom comes an important responsibility that we as citizens must exercise.
I would say I've already shown my hand a little bit, and that the way that I would answer the question, what does it mean to be free, begins not from the outside in, not from what that means and what we do, but from the inside out in terms of the who. So as an individual, what does it mean to be free? I would say what it means to be free is to have the opportunity to discover one's worth and unleash one's fullest potential on the world. And so to answer your question about the democratic schools movement, I have an uneasy place in that. Briefly, I would explain the distinction as this. I think we can all see the problem with teacher-centered environments where maybe the teacher is, and that's like the old school model, right? So if I'm the teacher, all of the knowledge is in my head, there's a clear hierarchy, I have to impart it to you. Black spoke to this in the Tinker case where he's like, what happened to the old adage, children are to be seen, not heard? And he was saying, like, can we bring that back, people? A lot of democratic schools, but not all, react by just swinging the pendulum in the other direction where they make student-centered environments. But there's a distinction here with the role of the adult, and I think it's one thing to not want to be an authoritarian adult presence in a classroom, which is, I think, the right impulse. But we can sometimes make the mistake of erring too far on this side and abdicating our responsibility to be authoritative facilitators of learning. And so to me, the ideal environment for learning is subject-centered, whatever that subject is, whether it's a poem, a math problem, a science laboratory, a core question for the student council. But that brings with it a different set of skills and responsibilities, and I think one of the biggest problems, generally speaking, in the democratic schools movement is there isn't clarity about that distinction.
Other questions?
Right behind? Yeah.
I just wanted to ask you, on the boys and girls in school, if they get harassed and people gang up on them, is there honor, or not honor, but are they being harassed to the point that it's really hard for them to be there?
Well, and I want to be a little, forgive me for being a little brief because we're getting a little late and there's other people that have questions, but the bullying raises a whole variety of First Amendment issues. On the one hand, our schools cannot be havens for rampant intimidation, for threats against people. I mean, that just cannot be tolerated. On the other hand, when you say bullying, I mean, what does that encounter? I mean, if somebody were to say, on their website, Jesus believes, I'm a Christian and Jesus believes that homosexuality is a sin, is that bullying? Some places, believe it or not, it has been deemed that. So on the one hand, we have to make sure that First Amendment freedoms are protected. On the other hand, no one has a right to intimidate and threaten someone else.
The one thing I would just add very briefly is there's a very clear distinction, and it's essential that school leaders see it, between the fact that their primary responsibility is to maintain a safe learning environment for all kids. So kids must not be bullied while they're at school. And there's a distinction depending upon the facts, between that, which is clearly not allowed, and a student bringing in an idea more generally that is unpopular, and that being censored under the guise of bullying. So one is clearly inappropriate, the other is a wolf in sheep's clothing.
Right next, and then, sir, we'll come to you. And then.
Hi, thank you. I was struck before, I think it was by Ronald Collins' comment about the wife in the case and how would she feel about it. It seems to me that when I've read about this, these kinds of cases, and I was also originally trained in history, but there's kind of a Cinderella-like quality, which is, it's either the glass slipper, the person who brought the case probably lives happily ever after, or it may be, although we don't tend to know, it's the early part, of the Cinderella where she's scrubbing the floor. So do your stories, but the human part of what that costs people, like the example you gave, my question is, do your stories tell us what happened to the protagonists after the event?
Yes.
We think so, but you'll have to tell us. That was our intention.
No, they do.
The great legal issues, but it's the human issues as well.
That's right.
When we discussed, we were at Politics and Prose Bookstore, a wonderful independent bookstore, and a shout out for independent bookstores several weeks ago. I talked about the Anastopoulos case, and I said, how many spouses out there would have agreed with George Anastopoulos, disagreed with George Anastopoulos, and my wife raised her hand, and that's, there's a sacrifice, and it's one thing to say, I will make the sacrifice for myself. All right. A companion case to the Anastopoulos case was the Raphael Koenigsberg case, basically the same thing out of California. And Koenigsberg's wife never, ever, to the best of my recollection, I could be wrong, but never quite forgave him for what he did. And again, there's a price, and at some point we all pay the price, and where one's the sacrifice we make. But the answer to your question is, as best we can, we do tell how the story ultimately played out. Yes.
Sir.
What's the difference between protected free speech and hate speech, and what are the rules for making that call?
Basically, in very short, the court had a cross-burning case out of Virginia, actually, several years ago.
We have a chapter on this, too.
Yeah, we have a chapter on this. But at the point at which, well, first of all, you can't trespass. So if I burned a cross on your front yard, that act of trespassing, you cannot threaten somebody. You cannot exercise a clear threat. If I say, if you'll allow me, I'm just saying hypothetically, you're a crazed Republican, and may you rot in, that may be protected. But if I say, you're a crazed Republican, and the next time I see you, I'm going to exercise my Second Amendment rights, and and go a little further than that, then that. If that would put you in reasonable fear, then that sort of thing is protected. So hate speech, the idea that just something that one hates a group or something like that, that alone, standing alone, is not enough. There has to be some threat related to it.
One thing I would just add to that real quick, I think this is right, that every hate speech law in this country, and what the chapter we talk about, there was a wave of them that came out in the 80s. I'm 40, I remember, because I was at the University of Wisconsin. I was a part of one of the draftings of
40?
Those hate speech laws, and I've since, in my own journey, I've since come and see the folly, the well-intended folly of trying to craft a hate speech law, because it doesn't work that way. So I believe every single one has been struck down. But there is something now, penalty enhancements, to just be a little bit more specific. So I can be arrested for assault if I and a bunch of friends beat somebody up. That's pretty clear cut. If it can be proven that the person we targeted because of their race or their ethnicity or their sexual orientation, there can be an enhancement to our punishment, which is fundamentally, first and foremost, about assault. But there's an enhancement because of the fact that it was motivated. That seems to be the unsteady alliance of.
We have time for one more question. Right here.
So at what point would each of you draw the line? Is there a point at which you would fear a First Amendment issue?
There are probably many points. There are many points that I said as a parent, although the First Amendment doesn't apply to me in my relationship with my son, but there have been many times when I felt very censorial, and I had no qualms about it, and he would raise First Amendment defenses, and I'd say, I'm not the government. Which is something to keep in mind. The First Amendment only restricts the government. So, but there are any number of places, I think, where I would have some reservations. But I think the toughest one for me, and it's one why I speak so easily about the Anastopoulos case, is when it involves my family. It is when stepping forward and exercising that First Amendment right and trying to defend that First Amendment principle. When the Phelps, by the way, their case first started, I got a phone call from them asking me if I would assist them. And I said, no, I can't for any variety of reasons, one of which is where I was working wouldn't allow me to litigate any case, not just their case. But I will say this as a shout out to the Thomas Jefferson Center. I couldn't find a law firm that would be willing to defend them, even firms that did First Amendment work. I couldn't find anyone. And when it came to the Thomas Jefferson Center, I think to their credit, and consistent with the United States Supreme Court has just ruled 8-1, they stepped forward when others stepped back. And when you asked me a question, what can I think of any examples where somebody represented a cause that they absolutely loathed? I think the Thomas Jefferson Center is a good one, good example. And I think, with all due respect, I think, ladies and gentlemen, we are all the better for it.
Thank you. That's very nice.
I think in some respects the facts of the Phelps case come as close as any that I've seen to. I think Black and others before him got it right when they said you don't punish speech, you punish action. And so to the greatest extent possible, I feel like that's my line. We'll see. But it's what's so powerful about the question is making sure that all of us continually ask it of ourselves.
If I could just end on a positive note, this is the last line, the last paragraph of our book. Clearly, change is not always better, and yet we can afford to take a few more chances in order to live in a world where, to the greatest extent reasonably possible, First Amendment freedom is our collective default position. It is a risk worthy of a free people. In that spirit, then, and with that sentiment at heart, we enthusiastically echo Willa Cather, Coraggio Americano.
Perfect point on which to end this. Join me in thanking.
Grace Elizabeth Hale, in your book, A Nation of Outsiders, you devote a whole chapter to J.D. Salinger and A Catcher in the Rye. Why?
Well, I think Salinger is interesting because his character, Holden Caulfield, is really